Voice 12, the Courtroom Voices from AAA Insolvency. I am Anil Goel, the founder of AAA Insolvency. Today we are going to discuss a judgment whereas the insolvency of GVK Power and Infrastructure Limited has been initiated by NCLT. Now the judgment is important because the enforceability of the foreign judgments in India is in this judgment. GVK Power and Infrastructure Limited is engaged in energy, transportation, hospitality, life sciences and real estate, and even the ownership of the airport of Bengaluru. So the Bengaluru airport ownership in fact was exited in 2017 when it was sold to a company in Canada, and the GVK was also the owner of the Mumbai airport, and that was also sold to Adani Group in 2021. The applicant in this case was ICICI Bank, the financial creditor. The date of admission is 21st July 24. The order was from NCLT Hyderabad bench, and the primary legal issues involved in this judgment was jurisdiction and enforceability of foreign judgments in India and other issues. Now the brief background is that the ICICI Bank Limited, they sought to enforce a foreign judgment obtained from High Court of Justice, King's Bench Division, Commercial Court, London, against GVK Power and Infrastructure Limited. The judgment was for recovery of the amount due under a series of loan agreements granted by GVK Power. The loan agreements were in fact executed, various loan agreements were executed. One was on 17 September 2011, a term loan of 1 billion USD, which is approximately 800 crore, and a letter of credit facility of about 35 million US dollar, which is about 300 crores of Indian rupees, were sanctioned to GVK Coal Developers Singapore Pte Limited by a syndicate of lenders including ICICI Bank, and another term loan facility of about $44 million were also given, that is about 350 crore, and that which was later increased to $250 million, which is about 2000 crore, that was also sanctioned to the facility. The facilities included the large loans intended for international projects like coal mines acquisition in Australia. The security given in this case was GVK Power and Infrastructure Limited hypothecation of its accounts and pledged certain shareholdings in GVK Energy Private Limited and GVK Transportation Private Limited as security for the loan facilities. Additional securities were provided through hypothecation deeds and equity subscriptions agreements. Now the principal creditors in this case was ICICI Bank Limited, including its branches in Dubai, Bahrain and Singapore, which led a syndicate comprising other banks. The other syndicate banks were basically Bank of Baroda, their branch in Ras Al Khaimah, Bank of India, their London and Singapore branch, Canara Bank, their London branch, and Indian Overseas Bank and Axis Bank. The corporate guarantee was given by GVK Power and Infrastructure Limited, and the guarantee was given to 3 loans, that is in March 2016. Now what triggered the default? First of all, the lenders saw that without any permission, the potential sale of Bangalore International Airport was actually without their consent was taken place. This company was holding 43% shares in airport company, the company which set up the Bangalore airport and also managing it, and that was sold to Fairfax Financials for about 3,500 crore. This is a Canada-based investor, a kind of Warren Buffett of Canada, and the banks, in fact, in financial year 2016-17, the accounts were classified as NPA, and in November 20, ICICI Bank invoked the corporate guarantee due to defaults. Now the invocation of the bank guarantee was done and notices were issued. The bank demanded repayment of 530 millions of US dollars and also 891 million US dollars under the facilities agreements. The action was initiated in the Commercial Court of UK and later on NCLT in India. Now ICICI Bank claimed that the default and invoked the corporate guarantee due to non-payment of loan amount by GVK Goel Developers Singapore Pte Limited. The debt and default was acknowledged by the corporate debtor and in fact in the various annual reports. So they invoked the provisions of section 7 of IBC to initiate the CIRP. Now what the respondents were saying? So the respondents like GVK Power, they were contesting that there is no crystallization of debt so far. Even the invocation of guarantee was premature due to ongoing adjudication in the London court. They also claimed that the default occurred within the moratorium period under section 10 capital A of the IBC, that is between March 2020 to March 21. So therefore, the ineligibility of CIRP initiation. The jurisdiction and the enforceability of the foreign judgments in India was also their argument. They were also challenging that. Section 10A, validity of the corporate guarantee, determination of debt and default status. So this was all discussed. And then finally, even the section 13 and section 44A of the Code of Civil Procedures 1908 was also discussed. Section 128 of the Indian Contract Act was also discussed. Jurisdiction and enforceability of the foreign judgments in India. This enforceability of foreign judgments in India is governed by section 13 and section 44A of Code of Civil Procedures 1908. Section 13 outlines the conditions under which the foreign judgment is considered conclusive, while section 44A provides the mechanism for executing foreign decrees from reciprocating territories. Section 13 of the CPC says that a foreign judgment shall be conclusive as to any matter directly adjudicated upon between the same parties except in certain circumstances such as lack of jurisdiction, not given on merits, based on incorrect views of the international law, against natural justice, obtained by fraud, or founded on a breach of Indian law. Section 44A of the CPC says this section allows for the execution of decrees from the courts in reciprocating territories as if they were decrees passed by Indian courts. The decree holder must file a certified copy of the decree along with a certificate from the foreign court stating the extent to which decree has been satisfied or adjusted. Now, in this particular case, the judgment was passed by Commercial Court London against GVK Power and Infrastructure Limited. The judgment was for the recovery of amount due under a series of loan agreements granted by GVK. The foreign judgment from London's court required GVK to pay substantial sums due under the loan agreement. The judgment was obtained after due legal proceedings where GVK was duly represented but chose not to contest in the final hearing. Now, Indian court's perspective, NCLT had to determine whether the foreign judgment could be used as the basis for the initiating CIRP under section 7 of the IBC. The court noted that the Indian NCLT court noted that the foreign judgment was passed after following due judicial process and did not fall under any of the exceptions outlined in section 13 of the CPC. Now, various other judgments were also relied, various other judgments, like in fact so many foreign judgments were also relied, and but then finally what we can say that the NCLT admitted the application filed by ICICI Bank and initiated CIRP against GVK Power and Infrastructure Limited. The court recognized the default and acknowledged the invocation of corporate guarantee. Now, this judgment, how does it impact the industry? The judgment reinforces the enforceability of corporate guarantees under the IBC and supports lenders in initiating CIRP against corporate guarantors. It also highlights the significance of adhering to the terms of loan agreements and corporate guarantees. It sets a precedence for a treatment of foreign judgment and their influence on the insolvency proceedings in India. Now, the conclusion is that the ICICI Bank versus GVK Power is a landmark case that highlights the justification, jurisdiction and enforceability of foreign judgments in India. It reaffirms the legal principle under the CPC, provides clarity on the use of foreign judgments in insolvency proceedings, and boosts confidence amongst the international creditors. This case sets an important precedent for future cross-border financial disputes and enhances the attractiveness of India as a destination for international investment and financing. This is all, my dear friends. Thank you very much.